Technique 1, the charitable remainder trust with make-up provisions. This should be used in combination with other techniques. A trust is basically a contract where one person provides the funds and another person agrees to follow the instructions of the fund provider. As strange as it may seem, the provider or settler can be the same person as the trust agrees to carry out the instructions. Trusts may be changeable or not changeable after they are drawn. The charitable remainder trust basically says this: I give these funds to a qualified charity. Charity cannot have them until I die. While I am alive, I want the income produced by the funds to be paid to me for life or to someone I designate as long as they live. In exchange for my promise to give the asset to charity, the IRS agrees not to tax the sale of the asset with capital gains tax. I get an immediate tax deduction and an estate tax is reduced. By using insurance paid for by the tax savings, I get more than I give the charity. Well, that is great for taxes. What about protecting my income? Let's assume I lose a lawsuit. Can the winner take that money from the charitable remainder trust? The answer is no. I don't own it. But what about my income? Well, because I am the trustee and control where the money is invested, I will choose a growth investment which does not have income. But the income will still be owed me, and the asset will continue to grow until the difficulty passes. Then I can invest in income-producing assets and collect all that back income. It is much easier to settle a lawsuit for less if to pay the entire bill is not available to the winner. Remember that the asset is not owned by me, and the asset locator will probably not find it. If he does, he will know that I do not own it. That is how the charitable remainder trust with make-up provisions works to protect your assets. Attorney's fees to establish the trust are currently $500. Technique 2, the family limited partnership. This is simply a limited partnership made up of family members. A limited partnership is a business agreement between the managing partner and limited partners, which allows the managing partner to control the business and the partners to invest in the business. The assets of the limited partners may not be taken from a properly drawn partnership agreement and sold to satisfy a judgment. The general partner may be the same person as the limited partner with other family members. Limited family partnerships are often used to reduce the value of assets for estate planning purposes. You can expect a reduction in value for estate tax purposes up to 50%. But how does the family limited partnership work to protect your assets when you lose a lawsuit? Let's look at the sample language that makes this possible.
On application to a court in jurisdiction by any judgment creditor or a partner, the court may charge the partnership interest of the partner with payment of the unsatisfied amount of the judgment with interest. To the extent so charged, the judgment creditor has only of an assignee of the partnership interest.
This means the creditor becomes a limited partner, and the limited partner has no rights other than to collect disbursements. But should this happen, there will be no disbursements to this limited partner. Prior to the lawsuit, you contributed your assets to the family limited partnership. You are in control of the partnership as the general partner. Most of your assets are held as a limited partner, both a limited and general partner. The partnership agreement states that your limited partnership assets must stay in the partnership. Not only may those assets not be taken from you, but if the partnership has a profit which is not out, the person who tries to collect the limited partnership interest will have to pay income taxes on the profit they do not receive. I would guess as a general partner, you would elect not to pay out those profits. Naturally, you can borrow money from the partnership or hire yourself as a consultant. Can you imagine winning a lawsuit and not being able to collect, as well as having to pay someone else's income tax? This is a powerful tool for settlement. Attorney's fees for family limited partnerships are currently $2,000. Technique 3, the Family Registered Limited Liability Partnership. This type partnership is being adopted throughout the United States. It is different from the Family Limited Partnership because it provides liability protection for the general partner for activities of the partnership, when a statutory amount of insurance is provided to protect the general from errors and omissions. Let's look at that language.
The partner in a registered limited liability partnership is not individually liable for obligations or liabilities of the partnership, whether it's contract or otherwise, while the partnership is a registered limited liability partnership.
The general partner assets are not protected in the family limited partnership unless they are held as a limited partner interest. Remember, you will be both a limited and general partner in the family limited partnership, and most of your assets are held as a limited partner. Much of this family registered limited planning has to do with protecting an active business partnership. It is an additional benefit that this structure is available to protect your assets. Technique 4, the Family Limited Liability Corporation. This business entity has gained favor since the Internal Revenue Service has agreed to tax it as a partnership. The advantage of partnership taxation is that each partner is taxed directly based on their interest in partnership. There is no double taxation. All profits and losses pass directly through to the partners for tax purposes. Many advisors are recommending the Family Limited Liability Corporation over the Family Limited Partnership, but we do not have a large enough number of lawsuits to really know how this will work. It is designed to work in a manner similar to a family limited partnership, but it provides greater protection for the manager of the family liability company than the law provides for the general partner of the family limited partnership. Attorney's fees for a limited liability company are currently $2,000. Technique 5, the International Asset Protection Trust. Americans often feel that we are the best in the world. But ask yourself, do we have the best litigation system in the world? Anyone can sue you for, they could win and collect, and what you had would now belong to their lawyers, your lawyer, and the winner, but not with an International Asset Protection Trust. This technique establishes a trust in a special foreign country referred to as a tax haven. These tax haven countries have created an industry just to protect your assets and save you taxes. There are no taxes to be paid to the tax haven. In 1981, the IRS commissioner 29 tax havens. Your wealth can grow there tax-free. If a creditor tries to take your assets held by the trust in the tax haven, the United States judgment is ignored. It is not worth the paper it is written on. The International Trust does not mean you must invest your assets in that country or any foreign country. You can still have your assets in the United States, but there are tremendous advantages in investing outside of the United States. The returns are 3 or 4 times more than U.S. investments and tax-free. Here is a magazine devoted to offshore investments. Remember that the top 1% of the income earners now pay more than 1/4 of all individual income taxes. The International Trust does have a major drawback. You must file several tax returns which tells the IRS exactly what you are doing with your assets.